Well, I want to welcome everybody to our discussion this afternoon on international justice. I'm Jim Goldgeier, Dean of the School of International Service, and it's a great pleasure to welcome our guests this afternoon and to welcome all of you. I'm just delighted that we are partnering once again with the French-American Global Forum, and I will introduce Romuald Sciora in just a moment. But so we have two panels this afternoon. And the first panel is on international justice, the role of the International Criminal Court. And we have our panelists already in place here. Our moderator, Carola Weil, Dean of the School of Professional and Extended Studies here at American University, and just delighted that my fellow dean could join us here this afternoon for this panel. With our panelist, John Bellinger, partner at Arnold and Porter, and former legal advisor to the U.S. Department of State, and David Bosco, who is a professor here in the School of International Service, a contributing editor at Foreign Policy, and who's written books on the United Nations and on the International Criminal Court. And then we will have a short break, and then I will chair the second panel. And we have joining us for that Stephen Rapp, Ambassador at Large for War Crimes Issues at the U.S. Department of State, and François Rivasseau, Deputy Head of the European Union Delegation to the United States. We are delighted that the delegation of the European Union, as well as the School of Professional and Extended Studies, are co-sponsors of this event, along with the French-American Global Forum. As I mentioned, we've partnered with Romuald on a number of occasions over the past year or two, and it's been a real treat to work with him. He has a very interesting background because he is both an author and has written books on the United Nations, but he's also a documentary filmmaker. And it is a very unusual combination. He's written, or he's produced a TV series devoted to the United Nations called At the Glass Building, and he's doing great work with the French-American Global Forum. And I'm pleased to welcome him up to the front.
Thank you, James. Good evening, and thank you to be with us tonight. Thanks to our speakers, moderator, and to the delegation of the European Union to the US to be the main sponsor of this event. Just in few words to introduce the French-American Global Forum. For whom doesn't know it, the French-American Global Forum is an organization based in Washington, D.C. and now in New York. We organize a symposium, forum, conference, etc. Around different topics regarding international matter from an European, American point of view. We are also starting a series of publications next year, some new book about the UN, and the French-American Global Forum is also one of the co-producers of my new documentary about and with Zbigniew Brzezinski, but also with President Carter, Henry Kissinger, and Madeleine Albright, movie about the work of Zbigniew Brzezinski during the administration of President Carter. This movie will be presented next spring in Washington and in New York. Thank you very much, and enjoy this symposium. Good evening.
Great. Welcome, everyone. My name is Carola. Colleague Jim Goldgeier discussion. Both he and I learned as deans was we have very little time for substance. We spend a lot of our time making sure that trains run on time, that students get to their classes, that faculty are in classrooms, and all the rest of it. So this is a wonderful respite from our day-to-day lives, and I thank you all for coming here today. If you can't hear me, let me know. I won't go into any introductions of our panelists today. You have bios on your seats, but I do want to point out that while they both are lawyers, and you may have your opinions about lawyers, What really, I think, makes this panel stand out is the practical experience that both of these men bring to their knowledge. This is not just armchair litigation. This is really being in the trenches. So John Bellinger has, in fact, been one of the, I wouldn't go as far perhaps as saying architects, but certainly someone who has been very much involved in negotiating what we are going to talk about, the International Criminal Court of Justice. He also, for those of you who are real cognoscenti of international law, is one of the authorities on the law of the sea. And while that tends to be a bit of an obtuse subject matter, it is in fact one of the most critical conventions to the future of this planet. So I applaud you for the work you've done in those trenches as well. No less distinguished David Bosco, faculty member here, and also the author of this new book, which I thought I would bring with me, Rough Justice, among others, is someone who can speak from his experience in other trenches, in Sarajevo, among other places, where he really has had to think through what mechanisms, what tools are available to states to address complex humanitarian needs and emergencies. And so I'm delighted to share the podium with both of you. We are here to talk about the ICC, the International Criminal Court. And I would like to really run this as a conversation and perhaps start off with John Bellinger. The U.S. continues to be a non-member of the ICC. Why should we then even have this conversation? Why is it that the U.S. has continued to remain outside of the ICC, and in fact, as David Bosco has pointed out, has perhaps practiced a policy of marginalization over the years, and in some ways, in fact, has even restricted the ability of the U.S. to effectively play on the international stage?
Thank you. Nice to be here. Always nice to be back to AU. I accept all invitations to the School of International Studies, but it was actually the French connection that really got me, because I don't think anybody in this room knows that I was actually born in Paris when my father was working for NATO before we were kicked out by de Gaulle. So I'm sorry François Rivasseau is not here, but I liked the connection there. And then you're not going to get me going on the Law of the Sea Treaty. I talked so much about the Law of the Sea Treaty that for Christmas last year, my children actually gave me a little button that said, "Ask me about my treaty." So you don't want to do that. I will simply say that I talked too much about it, that one of the jobs of the legal advisor for the State Department, where if you've not read the bio, I spent my first 4 years in the Bush administration as the legal advisor for the National Security Council at the White House under then Dr. Rice, and then 4 years as the legal advisor for the State Department when she was Secretary of State. And one of the jobs of being legal advisor is being responsible for the interpretation, negotiation, and Senate approval of all treaties. And we had a very good treaty record. Well, the one treaty that we could not get through, despite trying, was the Law of the Sea Treaty. So maybe someone will ask me about that in the question and answer. But today we're going to talk about the Rome Statute. The Rome Statute, which is a funny treaty, because I always got asked, why is it called a statute? Since most treaties are either called a treaty or they're called a convention. This is one of the few that's called a statute, and statute just means a treaty. Is the treaty that was negotiated to create the International Criminal Court. So I'm going to talk for a few minutes about the U.S. relationship with first the idea and then with the real International Criminal Court from sort of an insider's perspective, and David, I think, will talk about it from an outsider's perspective, and then particularly about how well it's been doing. You're going to hear from Stephen Rapp on the second panel. Stephen's Ambassador Rapp is in the Obama administration, so he will talk to you about what the Obama administration is now doing. I'm going to mostly talk about the Bush administration, because that's the administration I served in, and then give a few observations now. The U.S. over 20, 25 years has had a sort of an ambivalent view move towards the idea of an international criminal court and then of the ICC itself. Starting back in the 1990s, our Congress actually supported the idea of an international criminal court, a international institution that could try war crimes, sort of like Nuremberg after World War II, that couldn't be tried elsewhere. And our Congress, then controlled by Republicans, passed resolutions endorsing the idea of an international criminal court, but that's subject to certain conditions. During the Clinton administration, the U.S. led the efforts at Rome, which is where the Rome Statute Treaty was negotiated, to create an international criminal court, and the U.S. was in the forefront of those efforts. What happened, though, is unfortunately what often happens with multilateral treaties that the U.S. starts supporting, but just, think about it. If you start trying to negotiate with all the people in this room, what you start at the beginning is not going to what is going to come out at the end. And so you can imagine if you try to negotiate something with 194 countries, big and small, what you start out with is not what you come out at the end. So the United States, through the Clinton administration, supported the idea of an international criminal court, but by the end of the process ended up opposing what came out at the end. Still supported the idea of a international court that could try war crimes, but ended up being concerned that the prosecutor of the court, and David will probably talk more about this in a minute, had so much power that was unconnected to states or even to the UN Security Council, that the prosecutor could go after countries and even the United States with no checks on him. At the end of the process of negotiating the Rome Statute, the United States, who had been at the forefront of the negotiations, then voted against the treaty. One of only 7 countries in the world to vote against the treaty. So the Clinton administration, really, who had been at the forefront, suddenly found itself as the caboose on the train, opposing a treaty that it had supported, even though it really supported the general concept, and largely over this idea of an unchecked prosecutor. So the U.S. voted against the treaty. What happens in the treaty process, though, is then you vote against, you vote for the text, then countries have an opportunity to first sign it, and then you join it. So the United States, then, at the very end, on the last day that the treaty, having been negotiated, and the U.S. had voted against it, then had the opportunity to sign the treaty that it didn't like. So President Clinton, on the last day in 2000, December 31st, did a funny thing. He authorized the United States to sign the treaty that he had voted against. But then at the same time, he issued a statement that said, we're signing the treaty, but the treaty is so flawed that I'm not going to send it to the Senate. And furthermore, I recommend to my successor, who at that point they were still in the midst of Bush v. Gore, I recommend that my successor not send it to the Senate. So I've said in the past that that's a little bit like smoking without inhaling. He signed it, but I dislike it so much that we're not going to become party. So the Bush administration then comes into office. I become legal advisor at the National Security Council. We had a number of senior officials in the Bush administration who really did not like the idea of this international criminal court, and nor had the Clinton administration, but we had people in the Bush administration, Secretary Rumsfeld in particular, who really didn't like it on behalf of the Defense Department. And so in 2002, after big interagency discussions, President Bush authorized John Bolton, who was then the Undersecretary of the State Department, to formally notify the Secretary General. I'm sorry, this is going to go on for a little bit to your question, but I thought the background here
absolutely
might be
essential.
To notify the Secretary General of the United Nations that the United States did not plan to become party. So President Clinton had already said, I'm not going to send it to the Senate. The Bush administration then went a step further and notified the Secretary General that we would not become party. That became, as some of you may know, known colloquially as the unsigning of the treaty. Well, you can't actually unsign a treaty. Once you've signed a treaty, it's signed. So the United States signed the Rome Statute. But what the Bush administration did was to formally notify the Secretary General that we didn't intend to become party. That then set off great unhappiness amongst Rome Statute members who thought that we were essentially declaring war on the ICC. At the same time, Congress got into the act, and we'll talk about this a little bit more in a minute. Congress, I think trying to be helpful, then passed a draconian piece of legislation called the American Service Members Protection Act in 2002, or ASPA, which basically prohibited all U.S. Support, assistance, cooperation to the International Criminal Court, except in certain circumstances, which again we will discuss. It even included, some of you may remember this, an odd provision that authorized in advance the president to use all necessary force to free any American official who was held by the International Criminal Court, which was going to be in The Hague. So this became known as the Invade the Hague Act. The Dutch were not very happy about this. I can tell you, I was still at the White House. The Europeans, of course, because they tended to blame everything on President Bush, blamed this on President Bush as if he were personally the architect of the Invade the Hague Act. This legislation was actually drafted by conservative Republicans in the House, and then it was approved by the Senate. Both Hillary Clinton and John Kerry voted for the American Service Members Protection Act. So I am often fond of reminding my European colleagues who would blame everything on President Bush that Hillary Clinton and John Kerry voted to invade The Hague before President Bush signed the legislation. Let me fast forward. I'll just say in the first term, this approach towards the ICC resulted in a real tension between the United States and Europe and other Rome Statute members. In the second term, as David has documented in his book, we took a much more pragmatic approach. I had moved over to the State Department. Secretary Rice had become Secretary of State. And we essentially reached out to our allies and said, look, we just have to agree to disagree. We're not going to become a party. Clinton administration voted against this. We've already said we're not going to become party, but we still see a role for the International Criminal Court in international justice. And in fact, very early in the second term in 2005, we abstained on a resolution that referred the Darfur genocide to the International Criminal Court. So we supported that. And then for the next 4 years took a gradually more, I guess, constructive and pragmatic approach to working with the International Criminal Court. I gave a whole series of speeches for 4 years saying, look, we're not going to become party, but we will work with the court within the confines of this law, the American Service Members Protection Act that Congress has passed. We will provide assistance where we can in cases that we think are appropriate, and we will essentially work with you. And I'll wind up here. I will say at the time, I think Europeans didn't really realize that this was happening in the second term, because frankly they'd gotten to be so annoyed with the Bush administration, they didn't really realize that the second term of the administration was in fact a much more pragmatic, it was a really different administration than the first administration. And so with this change happening in the second 4 years, there was an expectation that, well, you know, maybe if we just wait this out, we're going to get a better deal in the next president. The result was when the Obama administration came in, there was an expectation, as with so many other things, that there was going to be a dramatic change in policy towards the International Criminal Court, which then, of course, didn't happen. And there's been pretty much a continuum from the Bush administration's second term into the Obama administration. Some warmer rhetoric, some participation in the Assembly of State Parties, but the Obama administration very early on said, we don't plan to become party either. We're still concerned that the ICC might be used against us, and we will also support it when, in cases where we think that it is worthy of being supported. So with that background, to sort of frame the issue, I will say the United States, I don't think is going to become party to the International Criminal Court, in probably any of our lifetimes, unless the Senate dramatically changes. Stephen Rapp will say the same thing to you, that he does not think it's foreseeable that the United States will become party. And so we are going to live in a world where most countries are party to the International Criminal Court. The United States is not, but it still plays an important role in the constellation of international justice in the world. And as long as it is actually working on important investigations, despite its various problems that David will tell you about, the United States will be supportive of it within the confines of the laws that Congress has passed. So an important institution, but the United States has a somewhat ambivalent role towards it that has been fairly consistent with ups and downs throughout. So sorry to go on for so long.
No,
but
not
hopefully
at all.
I'll give you a little bit of background.
But in fact, David, if I could ask you to speak a little bit more from inside the workings of the ICC about this ambivalent role and the complicated relationship that you also describe in your book between the ICC and sovereign states, where you mention it is both an incredible transfer of authority from a sovereign state to an international body, but at the same time there's this very weak connection between especially the most powerful states who remain outside and the ICC. How has that impacted the effectiveness of the ICC?
Yeah, I think I think one thing that I in talking to people who were at the court in its very early days when it opened its doors, I think one of the things that really reinforced for me was the kind of fragility of this new institution. I mean, it had been negotiated at Rome. It opened its doors in 2002, but it had a hostile United States. It had a growing number of members, but also a lot of big states, not just the United States, that had decided not to become members. And so when you think about, I have a pie chart somewhere in my office. If you look at the world in terms of population, and you say, okay, there are now 120, almost 125 members of the court. But if you look at world population, you find that only about a third of the world lives in a country that is a member of the court, because who do you not have as members? Not just the United States, but you don't have China as a member, you don't have India as a member, you don't have Pakistan as a member, you don't have Turkey, you don't have Indonesia. So you've got big players, big populations that are not part of the court. That, Russia as well, I neglected to mention. So for an international organization trying to get itself set up, not having the support of the superpower, not having the membership of many other big players in the international system, it's an incredibly difficult thing. And I remember talking to one of the judges who took office in 2002, 2003, and he said, we would go to work. We had no idea whether this court was going to survive, whether it was going to take off, or whether it somehow might collapse. And so it had a very fragile beginning, and yet it had this very ambitious mandate of investigating and prosecuting the most serious crimes, and we're talking about war crimes, crimes against humanity, and genocide, wherever they occur, so long as the court has jurisdiction. And there were enormous hopes foisted upon the court by the international human rights groups, international civil society, the media. People were hoping that this court was going to really alter the trajectory of the world in some important respects, and certainly mitigate some of the most atrocious conflicts like those seen in the Balkans in the 90s and in Darfur and in Uganda and Congo and other places. The challenge for the court then and for the prosecutor was, where do we start? What do we do now that we're set up? And the court really started very cautiously. It tried in the first couple of situations that it looked at, it tried to get the state where the abuses were occurring, the government of the state where the abuses were occurring, to actually support the court's role. So it tried to actually work in partnership with the governments. So, for example, with the Democratic Republic of Congo and Uganda, which is where the court began its work, it got the Ugandan government to support and refer its situation to the court. It got the government of Congo to support and refer that situation to the court. So it was very much working in conjunction with the relevant governments. And I think that, as a practical matter, was very understandable. The court has no police force. It relies on the cooperation of states. It can't send investigators into a state without the cooperation of that and the permission of that government. And so it made perfect sense in a practical way for the court to forge relationships with the governments where it was operating. But that immediately leads to a question, which is, can you impartially investigate a situation like the violence in eastern Congo when your very work there is dependent on and supported by the government of Congo, which has been accused itself of abuses, or certainly being complicit in abuses. Now, in its first investigations, the court focused very much on crimes committed by non-state actors, by rebel groups. So in Uganda, the Lord's Resistance Army. In Congo, several of the militias that were operating in eastern Congo. And again, I think that's a very understandable choice. And in some respects, they were responsible. Certainly, if we look at the LRA, they were responsible for the most hideous abuses in those conflicts. But again, it started this question of, is this court really independent from states, or is it kind of a manifestation and an instrument of states? Is it working independently to investigate Congo, or is it kind of working on behalf of the Congolese government? So that was one important dimension of the court's work that started to come into discussion, and activists, I would say, started to get a little bit worried about the impartiality of the court and how effective it could be when it was relying on the sovereign state's good graces to be there. There's another question, I think, when we look at the actual operation of the court, but that goes to this same theme of how independent the court can be. And that is not kind of who it investigates and who it tries to prosecute within a given situation, but which situations does it select to investigate. And I think for many of you who have followed the court, you will know well that every full investigation that the court has launched has been in Africa. And this has become a real irritant in relationships between the court and African states. The African Union has passed a number of very harsh resolutions related to the ICC. There have been some real rhetorical spats between the court and African leaders about why this focus on Africa, why are you not investigating situations in other parts of the world? The answer to that question, I think, is complex. But I also think it comes back to this reality that the court is a fragile actor that is in many ways dependent on states, and dependent in particular on powerful states and their political, diplomatic, and economic support. And so I think part of the reason there have been many African investigations is because there have been a series of very severe conflicts in Africa, and a very large number of African states have decided to join the court, and thereby giving the court jurisdiction there. So that makes sense. But I don't think that's the full explanation. I think there are a number of other situations that the court, that it's hard to explain why the court hasn't been involved there, why it hasn't launched a full investigation, other than by looking at the geopolitics of the situation. And I would specifically cite the case of Afghanistan. Afghanistan is a place where there's obviously been long-running conflict, well before 9/11, but particularly since 9/11. You have had a very large number of civilians killed there. The UN, I think, estimates that it's at least 18,000 civilians since about 2005. The court has jurisdiction there because Afghanistan is a member of the court, and yet no full investigation has been launched. And I think you can look at a couple of other situations where it's a bit puzzling that the court has not opened a full investigation, specifically the situation in Colombia, the situation in Russia, the conflict between Russia and Georgia back in 2008, when Georgia was a member of the court. I think each of these situations has explanations, but I think it's, to me at least, it's clear that one element that's going on is that the court has been very cautious in treading into areas where major powers have very strong interests, A, or might be exposed to prosecution themselves, B. And so I think the court has avoided situations where it's going to run up against the United States, where it's going to run up against Russia, and has instead opted for politically safer situations in Africa, where those major power interests are more muted. Now, what does this mean? I mean, from the standpoint of someone who studies international organizations, it's not surprising that a brand new, very fragile international organization would decide to be pragmatic and careful about the politics of what it does. But putting on a lawyer's hat, it's troubling, because when you talk about international justice, you expect it to be impartial. You expect it to be applied whatever the politics of the situation, and certainly that was the rhetoric surrounding the creation of the court, is that this should be apolitical. It should be doing justice at a global level without reference to politics. This is the dilemma that the court finds itself in right now. It has adopted, I would say, a very cautious approach thus far. That has created increasing animosity, both from African states, but also, I think, some concern from civil society activists, human rights groups, about the performance of the court. And I think the court is in a very difficult position right now in trying to navigate through these early years of its existence, preserving its kind of political viability, while also trying to preserve keep the perception that it's applying justice impartially. And so I think it's a very difficult time for the court, and there aren't really easy answers out of this. I think one of the very interesting developments that actually just happened today is that the court has been seemingly getting a little bit more serious about the situation in Afghanistan. And that has included scrutiny of U.S. behavior in Afghanistan. Specifically, its detention practices, the allegations of abuse of detainees that went on primarily between 2003 and 2005 in Afghanistan. And if you look at the report that the ICC just released yesterday, it said for the first time, it actually identified U.S. forces as being potential culprits in some crimes in Afghanistan. Now, let me just clarify here. The court has not opened an investigation. We are a very long way from even the possibility of actual indictments of any U.S. personnel. But in a small way, the court has, I think, started to acknowledge that this perception that it's being careful on political grounds has started to hurt, and that it may need to take some steps to develop and preserve its reputation for impartiality.
Thank you. Ironically, the criticism that we have heard from many African states about the potential bias towards or against African states is one that has recently also been echoed by the North Koreans, who have, when a resolution was brought forward at the UN, argued that this was simply a reflection, the fact that African states had been targeted, that North Korea was being targeted, was simply a matter of subservience to who? The United States. John, how would you respond to that? If in fact, at the end of the day, everything goes through potentially the Security Council and the P5, does that in fact mean that the U.S. has a far more influential role on the workings of the court than we think, even though it is outside of the court?
Well, will not surprise you that I would say I think that's false. I think David will probably agree on this. I mean, one, not everything doesn't go through the P5. I mean, one, in the African countries, David's going to have the data better than I, but most of the situations in Africa were referred to by the African countries themselves.
Okay.
So that the African countries themselves asked the court to exercise jurisdiction. So it was not the Security Council getting together and saying, gee, look at all these conflicts in Africa, prosecutor, go and look into them. It was African states looking at these terrible conflicts and asking the court themselves to look into it. And unfortunately, as David says, many of the worst conflicts in the world, where we've really seen, I mean, bad things happen all over the world, but some of the really worst conflicts have happened in Africa, and the African countries involved have asked the court to intervene. One example where it did not was in Sudan, because Sudan was not a party, and Bashir was not about to ask the court to investigate the genocide that he himself was committing. So that was actually a case where the Security Council did refer the matter to the prosecutor. North Korea is probably similar to that. North Korea is not a party, has no interest in the International Criminal Court, and basically the International Criminal Court's been ignoring it for the last 10, 12 years, and there's now a bit more focus on it. But North Korea says these sorts of things. It sort of kicks and fusses when the rest of the world is criticizing it in any way. But I don't think this is a situation where the P5 has gotten together to suggest that the situation, the human rights situation in North Korea be referred. This is sort of an easy way for North Korea to try to kick back to say, oh, this is the imperialism of the Security Council, but it's really not.
Yeah, I would agree with that. But the situation, though, is that there is the concern that the political interests of the P5, of the permanent members of the Security Council, do have a big impact on where the court can operate. Because, assuming that you're not talking about a member state of the court, okay, so when a country is a member of the court has potential jurisdiction there. But when we're talking about non-member states, in order for the court to get jurisdiction, there has to be a referral from the UN Security Council. And so that then does throw it into the political realm, because I don't think anyone would be under the illusion that the Security Council is sitting back and they're purely jurists looking at the situation and saying, well, does this meet the threshold of crimes against humanity? No, they're political actors thinking about the politics, also the law, also the human rights, but I would say primarily the politics. And so that leads to a situation where Sudan gets referred to the court, Libya gets referred, neither of those were members of the court, but Syria does not, because Russia opposed it, because China was not very supportive of it. North Korea will not be referred to the court, barring some kind of collective hemorrhage on the part of the Chinese leadership, because China has a veto on the Security Council, and China will veto any referral of North Korea to the court. And so it's very clear that situations that I would say are in the same realm when it comes to gravity or severity of the situation, some get referred to the court and some don't. And that's the agreement that was reached at Rome, was that when it comes to non-parties, places where the court doesn't have jurisdiction, it's up to the Security Council to expand the jurisdiction of the court. So it's, the perception that politics is at work here is a very strong one.
If I can follow up on that with you, David, it has been noted that one of the court's greatest innovations has been the voice that it gives to the victims. And that currently, with some of the efforts to reform and make the court more efficient, merging some of the offices in the Defense Council, among others, that in fact is further undermining the voice of the victims and reinforcing some of these other more politicized perceptions. What do you make of that?
Yeah, it is interesting. I mean, this is not my area of expertise, but the court is quite interesting in that it does give the victims a role in the process, which is quite unusual from a kind of U.S. criminal procedure standpoint, where you have the prosecutor and you have the defense. There is lawyers that are assigned to represent the victims. The victims can participate in certain respects in the proceedings. And I think many people think that that's an important innovation, something that really adds a lot to the court. And I think part of the reason they think that is because there is a real problem with international justice of kind of a gap between the justice proceedings in The Hague and what happened back in wherever it was that the conflict occurred. And you heard a lot about this during the Balkan, the war crimes tribunals after the Balkans War, when, I mean, there you're not even talking about such great such great distances, but you had these trials going on in The Hague, and back in Sarajevo or Srebrenica or wherever, it just seemed very distant. And so one of the ways they tried to bridge that is by having a way for victims and victims groups to participate. But that means a whole layer of administrative costs. How do you identify the victims? How do you register them? How do you pay for their travel to The Hague to be able to participate? You pay for lawyers to represent them and their interests. And the court is under budget pressure because every state, particularly the biggest contributors to the court, sits down and looks at how much is this costing us. And the court is costing over $100 million a year, which is not a huge amount by many metrics, but for states who are engaged in austerity programs, they want to think about what are we getting for our money, and is there a way that we can make sure the budget of the ICC doesn't balloon. A lot of them have in their minds the experience of the Tribunal for the former Yugoslavia, which did really blossom in size and in expense, and states get worried about that kind of thing. So I think the victims' participation is under a bit of strain. And that's one of the many ways in which the procedures of the court, which are quite novel in some respects, are being kind of hashed out and worked through in practice. And a lot of that, I think, is still being settled. Just one other area in which that's the case is that the ICC has a relatively novel relationship between the prosecutor and the judges, that the prosecutor actually has to get approval from the judges to issue indictments. And the prosecutor has to get approval from the judges in order to open an investigation. So the judges have a role in what we would normally consider kind of the investigative aspect of a court's work that is quite novel, and that's been the subject of a lot of back and forth between the prosecutor and the judges.
John?
I want to make a related point to your question. Kate, you may be about to ask this, but in case it doesn't come up, then I'll forget it, because this is an important point for people to remember. So the International Criminal Court has jurisdiction now over three categories of crimes: genocide, crimes against humanity, and war crimes. And then soon it will have jurisdiction over something called the crime of aggression, which will come into effect in 2017, and we ought to spend some time on that.
Yeah.
So it's a court of limited jurisdiction, only certain crimes. But here's the key point. It is not a court of primary jurisdiction. It is a court of complementary or secondary jurisdiction. So what it's there for is if any of those offenses, genocide, war crimes, or crimes against humanities, are committed in some country, and then there is not a way to hold the perpetrators accountable in that country, even after maybe there's been a conflict, then the International Criminal Court sort of kicks in as a secondary court because the parties can't sort of take care of it themselves, or a successor government can't take care of it, or countries in the region can't take care of it. It is not supposed to be a court of first resort. So the problem is, unfortunately, in a lot of these places where there's been terrible war crimes, that the regime in power is continuing on and on and on, and it's not about to investigate itself. Or there may be a new regime, but it really just would like to put everything behind it. Or they just don't have the resources. So often there is not a way for there to be local justice. But this gets into what becomes one of sort of the big issues in international justice today. Is many people forget that the ICC is not a court of primary jurisdiction. So, various advocacy groups immediately see some bad thing that's happened somewhere in the world, and they immediately say, the ICC has to go investigate and prosecute. That's just wrong. That's not what the Rome Statute was set up for, ever. It basically is only for the most egregious, most systematic of crimes, and then only if it can't be investigated or prosecuted elsewhere. And so where you actually see this, you actually then start seeing tugs of war in cases where actually a country would like to investigate abuses, but certain groups are pushing the court to say, no, you should do it in The Hague. And then it begins to look more like a colonial court of Western justice sitting in The Hague being pushed by sort of outside advocacy groups. And here's an example on this. So in Libya, where the situation in Libya when Gaddafi was still alive was referred by the Security Council to the International Criminal Court, the prosecutor then issued 3 indictments of Gaddafi, his son Saif Gaddafi, and it was intelligence chief.
Yeah, Sanusi.
Yeah. So 3 indictments. We know what happened to Gaddafi. The war ended. The new regime came into power, and they immediately said, we want to prosecute Saif Gaddafi and the intelligence chief Sanusi. And so they had fled to different places. They were captured. The new government in Libya said, we want to prosecute these people. But the court itself, sort of pushed by a number of outside groups, said, no, we think that it would be more appropriate for this to be done in The Hague. In part, and probably rightly so, as they felt that there would be a swift trial and execution in Libya. But they said, no, we don't think that the Libyans should be given an opportunity. This should be done in The Hague. So we then get into a tug of war between the Rome Statute, which was sort of set up with primary jurisdiction in Libya, and the court in The Hague saying, no, we want to take charge of this. And this is, David can kind of give you the epilogue to the story, but this is basically still being fought out. Yeah. I'll tell you my views on this. I wrote an op-ed on it. I think this is actually one of the problematic issues in international justice today, is that we look too quickly to the court. The court plays a valuable role, but it is very, very expensive. It really cannot investigate everything. And so to me, the answer in Libya was, absolutely right. One would be very concerned about a fair trial in Libya. But the answer would be, and this finding connects back to the point about the victims, is that, well, instead of taking everything off to, if you have a 4-year-old who you're worried about his ability to do something, you don't say, don't do it, I'll do it for you. You say, let me help you do it. And that really is the same, what I think should have happened in Libya, is that to the extent that the rest of the international community was concerned about non-fair trials in Libya, it should have been, let's help the Libyans come up with fair trials. We will provide judges, we will provide assistance, because we obviously want to have a justice system in Libya going forward over the decades that will be functioning and fair. So we don't want to take it away from them and say, don't worry, we'll take care of this in The Hague. We want to say, let's help you do it in Libya. You may want to, you're more of an expert in this than I am, Dave.
No, I think
your thoughts on that.
The question of complementarity and when does the court decide that a national system is able to do something is a really complicated question. And there ultimately was an opinion in the Libya situation, at least as regards Saif Gaddafi, that the Libyan justice system simply was incapable, and therefore it needed to be done in The Hague. This gets really interesting in many respects, and the thing that I've been watching closely is how this gets applied, not say to Libya, but to say the United Kingdom or even the U.S. Because there's been an interesting development, which is that a group of lawyers and activists in the UK submitted a while back a dossier, basically, to the ICC saying that we think there are a bunch of crimes committed by British forces in Iraq during the Iraq War that were not adequately prosecuted, investigated, or prosecuted by the British justice system. And the ICC is now looking at that, and I think what's going on is that there's a back and forth between The Hague and London about, okay, what exactly did British justice or British military justice do about this case in Basra of some detainee being beaten, and did you investigate that adequately? Show us that you investigated it adequately. So it's kind of a back and forth. And that is also, I know, what's going on between very quietly between the U.S. and the court regarding Afghanistan, is that there's a conversation between the prosecutor's office and the State Department and the Defense Department about how thoroughly did the U.S. investigate detainee abuses in Afghanistan. Did it do everything that it needed to do? So this complementarity question is playing out not just vis-a-vis kind of weaker, conflict-ridden states, but also in some interesting ways with some of the more powerful states. And that is really a key question for the court. Ultimately, of course, what it comes down to is the ICC making a decision, because it's up to the ICC judges whether they think that the relevant state has taken the steps necessary. And that's, I think, why the United States was still part of the reason the United States was still uncomfortable with the Rome Statute as it was drafted, is they realized ultimately it is up to the judges. And the U.S. view may be, we investigated this. But if the ICC judges say, no, you didn't, then the ICC gets to decide that it could go ahead with an investigation or an indictment. So it's a key concept for the functioning of the court.
But if I may follow up on that, both with regard to Afghanistan and there was the case of Israel and whether or not Israel should be brought before the ICC a couple of years ago, and the court rejected that, in fact. John, you have argued in public and editorials for relaxation of some of the restrictions that you mentioned earlier that Congress has imposed through the American Protection Act, Armed Forces Protection Act, and other mechanisms. How do you see that relaxation working against the backdrop of behind-the-scenes discussions around Afghanistan, potentially also culpability in Iraq, relations with the Middle East? It could get very messy and very complicated.
So it's a great question. So one of the reasons that, in fact, I think the primary reason that Congress passed this American Service Members Protection Act in 2002, even with the support of a lot of Democrats, was that there was, and the reason that the Clinton administration voted against the Rome Statute was there was concern way back then that at least in theory, and this really is true, in theory, because David said it could happen, that a prosecutor who has full power and is not controlled by the Security Council could just decide on his or now her own that they're going to launch an investigation of the United States or of Israel and just say, we don't care that the United States or Britain or Israel has a perfectly functioning military justice system. We've just decided they haven't done a good enough job, so we're going to investigate. And so, that was why the Clinton administration voted against it. This is why Congress voted this statute, because they were concerned that a rogue prosecutor would start investigating the United States. Well, you will say, well, that doesn't seem to have happened yet. And I think the American Service Members Protection Act was an overreaction. Both prosecutors, there have been two, have actually acted quite cautiously for multiple reasons, including the reasons David mentioned, that probably did not want to upset the great powers in the infancy of the court, and also probably concluded that in the grand scheme of things is, am I going to go after genocide in Sudan, or am I going to go after, 2 or 3 cases of detainee abuse in Afghanistan? So what do? You have to make priority choices. I've argued that 10, 12 years later, it's time to relax some of these restrictions on U.S. Support to the court so that the United States can be more supportive. I mean, we are reasonably supportive. We provide intelligence where we can. We provide, other assistance. But I think the American Service Members Protection Act was, unnecessarily draconian. And that there ought to be some changes to the law that would allow us to support the court when it's in our interest to do so. And I think that's, the Obama administration would support that as well. You'll probably hear Ambassador Rapp say that. But, and here's your point, and your point as well, is if the court, though, suddenly turns on the United States, and it may depend on where this investigation of Afghanistan goes, this relative acquiescence that we've seen in Congress over the last 10, 12 years could stir up, particularly with Republican majorities in both the House and the Senate, could wake that sort of sleeping beast of hostility. It will just take, somebody to say, well, this is just what we warned you. The court is, in fact, going to go after the United States because for political reasons. Congress, in fact, had been slowly, I wouldn't overstate this, but had been gradually really getting more used to the court. A couple of years ago, and I think I referred to this in my op-ed, Congress actually passed legislation that authorized large rewards of up to $5 million for the delivery of certain war criminals, Joseph Kony and the Lord's Resistance Army, to the International Criminal Court. So, here's an odd thing. Here you have Congress who's passed this draconian legislation that says absolutely no support to the court, terrible organization, very worried about it. And then the Congress, still controlled by Republicans, and these were actually Republicans who were leading this effort, saying, well, but we'll actually give $5 million in reward to the delivery of certain people. So Congress is being sort of ambivalent here, and that gets back to one of my key themes of what I'm trying to say today, is the United States has got, on the one hand, has been supportive of the court when it's doing things that we think are appropriate, but if it were to turn on us, then you can see U.S. support would dry up, very rapidly. Instead of having legislation that provides $5 million rewards for people to be delivered to the ICC, we would probably have American Service Members Protection Act 2. So I'm not sure I can say that this is necessarily good news today. Well, in fact, I will say this is concerning news about investigations in Afghanistan. I think we'll see how that goes. Yeah. There have been past investigations, quiet, that we don't really see behind the scenes by the court, and at the end of the day, the prosecutors come out and said, I've looked at it, and I don't think it meets our standards. These are not the most severe abuses in the world. So if that's how it comes out, then I think hopefully the sleeping animosity will stay beneath the surface. But if you suddenly see the prosecutor saying, well, I'm very concerned about these events in Afghanistan from 10 years ago, or if it were to go after Israel because the Palestinian Authority joins the court and the prosecutor begins investigations of Israel in Gaza, then our Congress will turn on the court in a second, and we will be at American Service Members Protection Act 2.
And I think, just to clarify, I think, as I indicated, I think the possibility of a formal investigation of U.S. personnel in Afghanistan is still quite remote, but it certainly was a big step, and I know there's concern in the Defense Department and State Department about the ICC, even in a preliminary report, actually identifying by name the United States and saying that U.S. forces may have committed certain abuses. But I think we're still a very long way from any kind of direct confrontation.
I want to open it up to the audience. I know I see many expert faces in the audience and people who have questions, but let me just ask both of you. The ICC clearly gets battered and has been criticized for the lack of effectiveness. Many would argue we're crying wolf, that in 12 years of existence it has only successfully concluded, I think, 2 cases now. By most standards, we would say, well, that's a lot of waste of resources and money and effort and political capital, and is it really doing what it was set out to do to strengthen international justice? Is there an alternative?
Well, I mean, I think the alternative that had existed before the ICC was that for any particular conflict, you would set up an ad hoc tribunal. So that's what happened with Yugoslavia. That's what happened with Rwanda. Or in some other cases, you might set up some kind of hybrid mechanism that was partially composed of the national government and partially international to try to do investigations. And these would typically be after the fact, although ICTY was during the conflict. So that's really, I think, the alternative if you're going to do international justice but not through the ICC. Or you could simply leave everything to national governments, potentially regional organizations could play a role. That, though, I think to many eyes really opens the door to kind of broad impunity, which is, of course, what this whole international justice movement is designed to combat. So I would say the real alternative in a practical sense would be kind of specialized tribunals for particular situations.
And I'll just add 2 cents. This is really more David's expertise than mine, and particularly because I've been out of government for a few years. But I think this is also an important takeaway, is this court does not work very well. It's a great idea. It's necessary, I think, but it does not work very well. It's incredibly expensive. The prosecutor and the judges have made lots of different mistakes. It's very inefficient. It goes on, some of these things go on for years. Then they get reversed. There have been problems with evidence. So, you know, it is important to understand that even if one is the most committed to the idea of international justice, this isn't often much talked about, because if you're trying to get the ICC off the ground and up and running, you know, people don't, even its most ardent defenders don't want to talk about its problems. I think 10 years now that it's actually up and running, as David said, it's gotten out of its infancy. It didn't die. Even its more ardent defenders are now acknowledging that it's got issues. And, you know, people who are supporting it are then saying, all right, let's try to get it to work through these issues. I'm reminded, I think what Henry Cabot Lodge said many decades ago about the United Nations, because as you know, Americans love to criticize the United Nations. He said famously, the United Nations was created not to take us to heaven. It was created to prevent us from going to hell. And so I think, you know, you could sort of say that about the ICC as well.
Well, on that happy and optimistic note, I believe we have...
and that was supposed to be positive.
And it was. We have a microphone going around. If I could ask you to please identify yourself as you ask your question, and if you would care to specify whether you're directing it to a specific panelist, David Bosco or John Bellinger, or both. Please. Yes.
Hi, my name is Nassim Karosh. I'm with the Baha'is of the United States, and I co-chair the Washington Working Group on the International Criminal Court, which is an NGO coalition that works to support the U.S. relationship with the court. I wanted to thank both of you for your very insightful comments. Just a quick footnote on Libya, and then I'll ask a question. I think, you know, as you both know, the court takes cases that a country is unwilling or unable to prosecute. Sorry, and with Libya, I think the issue is not willingness, but ability. And, you know, it is now, Libya is now, has been so destroyed and is at the mercy of, you know, warring militias. I think the issue there, both with Saif al-Islam al-Gaddafi and then also really with Sanusi, I think it could be fairly said, there just isn't the infrastructure or the ability to try them fairly, and that's, I think, the issue. But I just wanted to ask, kind of on the broader point that you raised, David, and I'll put this to both of you. You know, you talked about the hopes and expectations that people had of the court and how they were largely unrealistic maybe in many ways. People thought that the court would suddenly change the face of the world or change the face of international justice, and maybe they thought it would happen more quickly than was possible. But do you think adjusting those hopes and expectations and having a more sort of realistic or long-term view of things, could the court actually change the face of the world over the course of decades, particularly with emerging literature about justice being the most durable foundation for peace rather than amnesties or other options, you know, and looking at kind of the slow burn effects of changing norms, ending impunity, promoting accountability, providing restitution to victims. I mean, do you see in the long term the court being able to really have a very tangible effect worldwide in terms of justice and peace?
Yeah, I think that's a really important question, and it gets to something that I'm glad you brought that up, because I think one thing that we can definitely say the court has achieved is that it has put justice on the international agenda much more squarely than it had been in the past. And so any conflict now where there's significant abuses, there is the possibility, through a council referral if there's no jurisdiction otherwise, for there to be an international justice mechanism. And that means that justice and accountability are part of the conversation related to every significant conflict with widespread abuses. That's important. That's important that justice is part of the conversation. And I think it's also important to recognize that there may be, and this is very hard to document or to kind of point to in concrete terms, but there are very likely are what you might call shadow effects of the court. So yeah, it's doing its investigations in Sudan, in Uganda, and Congo, but presumably the work of the court and the spectacle of Bashir being subject to an indictment and Gaddafi having been indicted, that presumably resonates with national leaders, with senior officials in other countries. And so I would be surprised if there isn't some kind of shadow effect, some kind of perhaps conflict mitigation, or at least that this is entering into the consciousness of political leaders and military leaders that, hey, this exists out there and it could be applied to me. So I do think that's a very important point. I actually sometimes think that the effect of the court may actually be most significant not in the situations that it's investigating, which are extremely difficult conflicts that are intractable in some respects, that have very complex roots, but more broadly on the international stage by elevating the issue of justice and accountability. Because if you look to, for example, Sudan or Congo, and you try to say, do we see some kind of significant improvement that we can attribute to international justice? Very hard to say that. You know, the situation in Sudan, the conflict has evolved. There are new phases. There are still significant allegations of large-scale abuses. It's very hard to say that there's been a deterrent impact in Sudan or that there's been one in Congo. But I would be more hopeful about there being a kind of diffuse but real deterrent impact on the international stage more broadly.
I guess I'll just add very briefly. It's a superb question, and David just gave a superb answer. I mean, I agree with everything you just said. I think actually there really has been, I don't know that we have to wait decades, I think there really has been already significant effect, and the effect may be less in the individual trials that have been held than in the general either deterrent effect or just the sort of the sinking in around the world. Big countries like the United States or Britain, now worry about these things.
Yeah.
I'm not sure you can say that Assad or others sit there and worry, but they do. I think they probably talk. They probably joke at home in Damascus and say, well, I'm going to get hauled before the Hague one day. I mean, they do think about these things. For the worst of the worst, I'm not sure that it completely changes their behavior, but this court, for all of its warts, is having an effect around the world, and hence my comment about it's not a perfect court, but it's having it does play. You can make lots of criticisms of it, but it does play an important role. And I think, the important thing for U.S. policy has been, to come back to your very first question, is, it's there, it's having an effect, and what we ought to try to do is to, help to improve it.
Okay. Do we have other questions? No?
I'm just Joe Eldridge. I'm here at American University. Thank you very much for a very lucid and penetrating analysis. I appreciate it very much. I certainly learned a lot. I'm just a couple questions about how catalytic the ad hoc courts were in kind of preparing the ground for the evolution of the political debate surrounding the International Criminal Court, the ICC, and I'm thinking particularly in terms of the indictment, and additionally in terms of the indictment of Pinochet and the application and what that meant for the concept of universal jurisdiction as the debate around the ICC evolved.
So, well, let me take some pieces of that. So David alluded to this. If you're not an expert in the area, there were a number of ad hoc, meaning special purpose tribunals that were set up by the Security Council to resolve certain situations. So we have, and these still exist to a certain extent. The International Criminal Tribunal for the former Yugoslavia, called the ICTY, the International Criminal Tribunal for Rwanda, the ICTR, the Special Court for Sierra Leone. All of this, they were not set up by a treaty. They were set up by the Security Council, which to a certain extent was sort of, inflicting them on the rest of the world. And those have worked fairly well. They also have been, the ICTY and the ICTR were in The Hague and are essentially the precursors for the International Criminal Court. They too have been extremely expensive, extremely long-running, and have taken a lot of time. And the idea of a permanent international criminal court that could solve all situations or be available for all situations has been around for a long time, even before the ICTY and the ICTR. I think to a certain extent, to answer your question, the experience with the ICTY and ICTR both convinced states, well, that international criminal justice can be done. It can be very expensive, and that we ought to see if we can put this into a single tribunal so it doesn't have to be set up each time. And I think the United States supported that concept. The United States has provided by far more money for the ICTY and ICTR Special Court for Sierra Leone than any country in the world. I mean, we really have been the cornerstone of those tribunals. And we've now have not had to generally set up new ad hoc tribunals for some of these other situations. Would I add to that?
No, I agree with that. I think that's...
I think we have a question in the back there, and then one up front.
Thank you. My name is Felipe Franco. I'm a student here at SIS. Thank you both for your explanation on that stuff. I know that Mr. Bellinger, you explained the legal framework of the action of the court in terms of like war crimes, genocide, and crimes against humanity. And you mentioned the crime of aggression that will eventually be enforced in 2017. Well, this is basically a question for both of you. How is this new enforcement kind of changes the scope of the court? We know that several discussions has been made in terms of like the definition of this crime, if it's too broad, if it's too specific, or if in fact will change the action of the court in terms of prosecuting aggression in other states. So how is the relevance of that crime being enforced in 3 years from now?
And in fact, if I can add on to that, there's recently been discussion about Cambodia, and Cambodia presenting case of land grabs and forced resettlement of Cambodians to the courts. Would that fall under this more expansive definition of crimes of aggression, or how would we see that? Thank you.
This is a great question. In fact, I was sitting here saying to myself, it's too bad we glossed over aggression, and so I'm glad you asked. And what if you stick around, you should ask the same question to Ambassador Rapp, because this is actually really one of the great successes of the Obama administration. So when the Rome Statute was drafted, it covered 4 crimes, but only 3 were defined. So genocide, war crimes, crimes against humanity, all were specifically defined offenses, and the court has been operating for the last 12 years using those crimes. The Rome Statute also said that the court will have jurisdiction over the crime of aggression, but they couldn't agree on how to define what aggression was. But aggression basically means one country invades another, but they couldn't agree on it. And so they agreed at the time that it would be defined later. There was a review conference in Kampala, Uganda, 2 years ago, where the Rome Statute members, and including the United States as an observer, because we're not a member, sat down to try to hammer out what aggression meant. The United States was extremely concerned about this, because what country in the world is going to get accused of aggression more, just statistically, more likely than any other country? It's going to be the United States, because most other countries just sort of sit in their backyard, but the United States has a worldwide military presence. It's being asked to do things, and even things that the United States thinks it's acting properly. Like in Syria right now, other people may say, well, that's aggression. The Security Council has not authorized the use of force in Syria. That's a clear violation of the UN Charter.
Or Kosovo.
Or Kosovo, another example. So the United States has been concerned that that the definition of aggression as would apply to the United States. And I think the real worry of the Obama administration was, as they were trying to warm slightly and continue this sort of pragmatic approach that I described that began in the second term of the Bush administration, would have immediately gone into the deep freeze if the Rome Statute members at Kampala had adopted a definition of aggression and then applied it to the United States, and the United States, not even being a party, would then be hauled up before the ICC, when it might be just on a humanitarian mission, as David says, in Kosovo or in Syria. And really a great feat of diplomacy. The Obama administration, I think, basically said to the rest of the countries, look, if you adopt a definition of aggression and apply it to the United States, even though we're not a party, you will ruin any possible relationship for the rest of time. Going in, it looked like other countries were just not going to agree to that. They were going to say, we're going to do it anyway. And the administration, frankly, managed to pull a rabbit out of a hat and came up with a definition of aggression, which is quite broad. It won't come into effect until 2017. Countries that are not party to the Rome Statute, it does not apply to them, so it won't apply to the United States. And then other countries can opt out if they want to opt out. So this then, with that background, goes to your precise question. So when this kicks in 2017, well, what will happen? I think it's going to be a big worry, because the idea now is that you could have a single prosecutor in The Hague deciding whether different country, some aggressions are pretty obvious. One country's invasion of its neighbor may be in as an aggression, but is the United States humanitarian intervention in Kosovo or Syria, is that aggression or is that a humanitarian intervention? And the prosecutor gets to sit and decide those things on his or her own. Take Britain. Britain is a party to the Rome Statute. In 2 years, 3 years, it'll have to decide whether to opt in or opt out. But what happens if a country like Britain gets involved in a coalition mission on humanitarian intervention? It will then be very worried, well, could we be called up before the International Criminal Court for participating in what we think is humanitarian intervention, but another person's view may be that it's aggression. So, the United States has basically dodged this bullet diplomatically, but it will, I think, be a big issue for other countries starting in a couple of years.
Mm-hmm. One of the interesting things about aggression is that one of the reasons the United States was able to achieve that at the review conference in Kampala was that the P5 of the Security Council closed ranks on this issue. They basically all said, we are very nervous about this. We either want the Security Council to be kind of in control of whether the court would ever launch an aggression investigation, or there needs to be opt-outs. That was very different than at the Rome Conference, where you had a fracture within the P5, because you had Britain and France on one side, really, and the US, Russia, and China to an extent on the other side. At Kampala, they kind of closed ranks. The other thing that I think was important is that the human rights community, the civil society activists who've been so influential on ICC matters, were actually quite divided themselves about the utility of doing aggression prosecutions. So if you look at like what Human Rights Watch says, Amnesty International, a lot of these people are not sure that it's such a great idea, because as John was indicating, these aggression determinations become incredibly political right away, and they go to key questions about state policy and when states are authorized to use force. They also, and one of the other reasons I would say aggression is kind of not like the other crimes, or in many respects is not like the other crimes, is that aggression is by definition something that involves state policy and really goes to the top of the state. I mean, there's not going to be a prosecution of aggression by some local commander. Mm-hmm. It's got to involve the president, the prime minister, the defense minister. It goes right to the top. Whereas some of these other crimes, war crimes, crimes against humanity, even genocide in some respects, you can imagine culpability going to kind of only mid-levels, or aggression is not like that. And so that's another reason it's really a hot potato.
Thank you. We have time for one more question, unfortunately.
Hi, Matt Senni. I'm a freshman here at SIS. I was just wondering, as you say, given the fact that if in fact the United States was kind of at the forefront of the effort to establish the ICC, given the fact, given how opposed they've been to it, the fact that they voted against the Rome Statute, I was kind of wondering what the original vision going in was from the American perspective. I mean, I understand that their concerns were largely based around sort of the unchecked powers of a potentially, rogue, as you say, prosecutor. And I understand why the United States would feel vulnerable and they're at risk being, party given that. But since you still need someone to decide, whether a country's investigation of a certain issue really did live up to the standards it should have, then what body, if they're afraid of really one rogue individual, what body then would the United States have suggested to be responsible for this? And what was kind of the original vision going in? What checks did they imagine would be on the prosecutor that would sort of alleviate their fears if they really were dedicated to an international, system of this? Like, why? What were they going to do to make sure that they would not be at risk? Because clearly they felt that they would be. What checks were they expecting to be put on a prosecutor?
I'm going to go first. You just finished researching the history as
Yeah.
to what people thought were going in.
I mean, there were a couple different things, but I would say far and away the most important thing was Security Council control. Mm-hmm. If what the United States could have lived with and would have actually happily supported would be a permanent international criminal court that could only launch investigations when the Security Council said it could. If you do that, the United States is happy as pie because it has a veto power on the Security Council. Any investigation it doesn't want, it can knock down. And that's what, in effect, the United States was arguing for at the Rome Conference. The other P5 members obviously would have been happy with that too. The rest of the world wasn't so sure that that was a good idea. In fact, many people, many countries were vociferously opposed. And in some respects, I talked to one diplomat who was at the Rome Conference, and he said there was a little bit of like a replay of the negotiations about the UN and the Security Council and the veto power going back to 1945, because the veto power is itself a highly controversial element in the international system. And here what was happening at Rome was that the big powers were trying to say, sure, let's have a permanent court, but as long as the veto power gets extended to its operations. There were some other issues, but I would say that was far and away the most important. That was the check the United States wanted.
I would agree with that. And all I'll say is, I don't know whether you've researched this before, but if you're coming cold to this, you get an A+ for listening for the last hour. 'Cause you've summed up
It's a
the whole
great-
last hour in a, if when I were a freshman, if I could summarize something like that in 1 minute, it was a well done. But maybe you had already written like a 200-page paper on it.
I require that in all my classes.
No, I think that's right. That the Clinton administration really wanted to become party, and David Sheffer, who was the then ambassador for war crimes and who led the U.S. delegation, was really committed to this. And I think it literally, if you were here, I think it really broke his heart that they, that the United States, which has always stood for international justice, that had been. Nuremberg wasn't perfect either, but the United States had been at the forefront of that. That we had been, as you heard me say, the principal backers of the ICTY and the ICTR. So just really unfortunate that the United States at the end of the day had to vote against its own idea, and it really was if there had been Security Council control, just this check. Because the United States, because of our global responsibilities, is uniquely more likely to be accused. Unfortunately, as we now know after 9/11, very sadly for the Americans in the room, is there a lot of people who don't like the United States, and that's unfortunate. And what it means is that people who, even when the United States thinks that it's acting rightly, other people think that it's not. And so, they will then, refer things to the prosecutor, and if you get a prosecutor who shares that vision and decides, okay, I'm going to go prosecute the United States for actions that, seem to be appropriate, and I'm going to second guess every bomb, then, it really upset the Clinton administration's leaders at the time. So it's a sad thing that it could not be that it couldn't be worked out. And back to your very first point. So as a result, we then got to live in this world where this idea that we set up, we're not part of, we won't probably become part of, but that we hope that we can cautiously live with, work with, help, and then hope that it doesn't turn on us at some point.
Thank you. Well, I would like to take this time to thank both of our panelists, David Bosco and John Bellinger, and our audience for what I think has just been a wonderful, if very compact tour de force, deep dive into the International Criminal Court. And I think we have one more panel, and Anya, do you
Yes, just a
want to
quick announcement. Thank you,
conclude?
Carola. We will take a short break. There is caffeine on the side. There are facilities down the hall, and we will reconvene at 5:45 with our special guests, François Rivasseau from the European Union and Ambassador Rapp from the State Department. And there is delicious food provided by the European Union for those of you who persevere to the end. And please join me in thanking our excellent panelists.
Thank you.